I think that it was never really quite clear how they decided on the list. But I suspect that the main concern at that time was to clarify which commercial statutes would apply in Singapore. This is because there used to be a provision in another act called the Civil Law Act, which said that all mercantile statutes, statutes relating to commerce of the UK, shall apply to Singapore so long as there's no local statute that is applicable. So it's kind of a fallback clause. And this provision has created lots of headache for lawyers and academics for many years. Because you never quite knew whether a statute applied or didn't apply. And so their main concern was we want to get rid of that clause and replace it by a much clearer list. And so I don't think they actually went through the entire British statute book to say, oh, we should put this in, we should put that in. They really wanted to make sure we've got the main commercial statutes because that's the lifeblood of Singapore. And so, for example, the property lawyers will say, what about the great statutes that set out the land holding system, queer and Tories and all that? They are not on the list either, you see. But I suppose the assumption is that these principles are so well entrenched. You know, we're talking about principles going back to the 13th century, that really we don't really need to have a statute physically a part of our statute book anymore. It's part of the common law. So I suspect that's probably the reason why it was never put on the list. I mean, of course, if they had sent around a circular, I would have said, oh, please put it on the list. You know, we should have it, even if it's just for symbolic value. But at that time, that was, I don't think they actually went around surveying all the statutes that ought to be put on the list.
But I mean, Singapore is not unusual in that respect because the provisions of the detailed provisions of Magna Carta have been repealed in the UK as well. And it's this, so that it's not what it says in detail, it's what it signifies.
So it's currently it's more symbolic rather than
makes it such an important document.
Okay.
Yeah.
If I may just add a little bit to Jack's answer about the question, I think we have to try and understand that how did Singapore receive English law in the first place? When Singapore became a British colony as part of the Straits Settlements, basically the 1826 Charter of Justice brought in all of English law into Singapore. So it brought in not just the common law, which is judge-made law, but all the statutes of England that would apply. Now what happened subsequently over the years is that when you begin to have your own legislature, starting from 1867, you had the Legislative Council. You start making law for yourself. So that law that you make for yourself will always supersede any law that you receive from the UK, right? Because local conditions do matter. And over time, and here I'm just telescoping 140 years of time, we more or less replaced most of what we needed to replace by way of statutes. And what's in the common law? Well, it's just left vague. It's part of the common law. Magna Carta itself was never technically replaced as such, but it found a place, the key provisions found a place in already our constitutional documents. So there was really no need to look at it anymore. And as Jack rightly pointed out, in 1979, one of the problems that we had was, you see, we've always survived as a major trading center and a hub. And what the government was most concerned with is what if we do not have an appropriate commercial law for a commercial transaction? Then they wanted to have a fallback position. This is when they created this horrible Section 5 of the Civil Law Act. I used to spend 3 weeks teaching this because it was so awfully convoluted, right? Because of very bad phraseology. But basically, what was it? It was what we call a continuing reception provision that allows English law kind of a conduit to flow through in very selected circumstances. But it gave everybody a headache. I remember when I was pupilling in a law firm, we had one matter where we weren't quite sure if an English statute applied, and it was very easily settled. You know what? We told the other side, I think we've got a Section 5 problem here, and the other side offered to settle immediately, because there's a good chance that the court would say, well, this act doesn't apply, right? So that was what the Parliament was most concerned with, that we didn't have an adequate commercial law. And of course, it gave rise to lots of headaches, which led to the application of English Law Act 1993, which is why the schedule has only got commercial acts in there, because we are only concerned with that. in relation to the commerce side of things. We presume, of course, that we make law or we have made law for all other provisions already.